Hello and welcome to a session on copyright law and the marching arts. My name is Brian Tuck. I'm a nonprofit and arts and entertainment attorney based in Allentown and Chester County, Pennsylvania. It's a pleasure to present this content for Cavalcade of Bands. I'm extremely familiar with your organization going back to when I was in high school. In high school marching band, we were a member of Cavalcade, and throughout my teaching career, obviously, have also been extremely familiar with the organization. So I thank you for the opportunity to talk today a little bit about copyright law as it pertains to the marching arts. We will get into what exactly we mean by the marching arts in a second. If you have any questions at all following this session, you can find me I'm on all channels. So Facebook, Instagram, Twitter. You can visit the website at tuklaw.com. There's a contact form to use to submit questions. If anything that you hear today might trigger a question or two, or be relevant to a situation that you're in currently with respect to licensing of content. So let's get started. Quick bio. I'm a musician and a teacher of over 30 years now. I'm an alumni of the Crossman Drum and Bugle Corps from 1989 to 1993, and I graduated Temple University School of Law in 2000. I've served on quite a few nonprofit boards of directors, specifically with arts organizations, and as well, I represent a lot of more traditional entertainment law clients, such as record labels, songwriters, symphony orchestras, and youth performing orchestras, or I'm sorry, performing ensembles that may be in that are in the marching space, excuse me. We just need to do some legal housekeeping, occupational hazard, I suppose. The information presented today and in this recording is for general guidance only. So this presentation by itself does not create an attorney-client relationship. I am licensed to practice in Pennsylvania and New Jersey only, so nothing should be construed as legal advice in any other jurisdiction, and I think all of the members of Cavalcade are based in Pennsylvania. Okay, so let's dive right in. Copyright law, what does it mean? Well, quite literally, it means the right to copy, and that sounds very self-evident, but we'll get into all of the different definitions of this in a minute. The duration of copyright protection was changed not that long ago. Currently, for any musical composition, and that's generally what we're going to be talking about today, based on the nature of the activity, is the composer's life plus 70 years. So by and large, a lot of the literature, a lot of the repertoire is still under copyright protection, unless we're talking about some of the works that were written in the 1800s. So generally, compositions and especially anything in the popular sphere that if there are songs that were on the radio in 1970 and we want to arrange those songs, or we want to arrange something much more current, obviously those are all copyright protected, whether there's a federal registration or not, and we'll cross that bridge when we get there. So what does a copyright holder have? Well, a copyright holder has exclusive rights to do at least 6 major types of activities, and these are the definitions that appear on the front of the Federal Copyright Act. The copyright holder is the one that has the exclusive right, meaning no one else but the copyright holder can do these things. One, to reproduce the copyrighted work, either in a recording or in a paper or digital copy of the, of the musical notation. Two, to prepare a derivative work based on the copyrighted work. This typically, the classic example is if someone wants to compose a medley of 3 or 4 other songs, which is a very current trend in whether it's DCI or whether it's WGI, especially with indoor guard ensembles, where they may identify 9 or 10 songs that get rolled into the music that supports the choreography. So a derivative work includes medleys for our purposes. The third exclusive right is the right to distribute copies or phonorecords of the copyrighted work. Phonorecord is a odd word. A lot of this language is a little bit dated, but phonorecords now are interpreted to include MP3s, digital audio files, regardless of the compression format. Number 4, the owner of the copyright, in the case of literary, musical, dramatic, and choreographic works, has the exclusive right to perform the copyrighted work publicly. Now that does include a marching band contest. That does include a performance at a WGI show indoors. So if it is a performance of a protected work and that performance is in public, meaning more than just the performers being present, that is a public performance. Only the copyright holder has the exclusive right to do that. In a little bit, we're going to talk about licensing, which is the method by which the copyright holder allows a third party to do one of these 6 things. Okay, let's hit the last 2 quickly. If it's the right to display, number 5, really pertains more to visual arts or dramatic works or motion pictures, and again, really specific to our purposes today. Number 6 is also very important. In the case of sound recordings, it is the right to perform the copyrighted work publicly by means of a digital audio transmission. Well, what does all that mean? What that means is, if we pick a song, for the sake of argument, let's pick let's pick Jumping Jack Flash by the Rolling Stones. That's a song that has been recorded many times by different groups. There are copyright protections that attach to each one of those versions of the song, that follow the actual sound recording. So if we wanted to use, for example, we're building our show for the next upcoming season. Let's say we're designing a show for an indoor percussion ensemble to compete in one of the WGIs or MAPs or something like that, or Cavalcade or any of these any circuit. In the case of a sound recording, if we wanted to use the 1968 version of this song off of a specific live album that the Rolling Stones recorded, we would have to get permission from the owner of that particular sound recording. There are copyright protections that apply to the composers, and there are also separate protections that attach to the owners of sound recordings. So in other words, the composer, we would need to obtain permission from the composer And then we would also need to obtain permission from the record label that owns the recording. That sounds like it's very cumbersome. It's actually very easy, and we'll talk about how exactly to do that. Now, why is copyright law such a hot topic, and why are we concerned about it? This slide will show you why. We're concerned about it because there are significant financial penalties that attach to a person who has violated the Copyright Act. The Copyright Act provides that a copyright owner who has had their rights infringed upon are entitled to their actual damages and any additional profits of the infringer. Typically, this is more relevant when you have a rock band that's recorded a record 20 years ago, and then a hip-hop artist picks it up, samples it, and uses a sample of that older recording in a hit song and makes a lot of money. That's typically when this first bullet point comes into play. The second bullet point is much more relevant to us. Now, we are either part of school district ensembles, or we are part of small independent nonprofit ensembles. I, of course, appreciate that budgets are always a concern. Organizations very rarely have reserves of any kind, cash reserves, let alone a large cash reserve to pay for a legal issue that may arise or for damages under one of these claims. This second bullet point is really the hinge of a lot of what we're talking about. The Copyright Act provides that there are what are called statutory damages. In other words, the Copyright Act has a provision that says a judge, if they find infringement, may award between $750 and $30,000 per infringement as the court deems just. Now, what does that mean? Let's say, for example, we are an ensemble. We have decided to use a copyrighted work in our program, and we're going to go out and do 22 performances over the course of a season using this copyrighted work, and we did not obtain a license to do so. We did not obtain permission from the rights holders to do this. Each one of those 22 performances are separate violations. So, in other words, if a judge looks at our conduct and thinks that we have willfully violated the Copyright Act, in other words, we knew we probably should have gotten a license, but we didn't bother, or we thought it was too much money and we didn't, we opted to not go forward and pay for the licensing fees. Well, the judge can assess up to $30,000 per infringement. So in the case of a judge finding a $10,000 penalty per infringement, and we just did it 22 times, that's $220,000 or $220,000. In addition, the Copyright Act authorizes the judge to assess the plaintiff's attorney's fees and court costs if the plaintiff prevails in the litigation. So just on our example of our imaginary ensemble that has knowingly violated the Copyright Act and done it 22 times in a row, that's a cost that most organizations that I work with could not possibly absorb. So for that reason, copyright law compliance is really something we have to keep our eyes on, especially now that the rights organizations are looking specifically at the marching and pageantry spaces as sources of licensing revenue. And I'm sure some of us have had experiences with a certain organization who we won't name here, sending representatives to marching band competitions to basically police whether or not organizations obtain licenses for the works that they're publicly performing. So it is a very, I would say 10 years ago, this was a much more hypothetical conversation. However, based on the events of the last 2 seasons, I would say that this is a very real issue that we should be concerned about, and we should do our homework up front in order to avoid, avoid any possible legal entanglements. What is copyrightable? Let's switch gears for a minute. It's important to know that while we are primarily talking about music, there are many other creative works that can be copyrighted. Literary works, novels, short stories, biographies, etc. Dramatic works, plays, monologues, film scripts, etc. Choreographic works, and again, probably most important for our purposes, sound recordings. Now, I've fielded a lot of questions about the fair use doctrine, and we should spend a little bit of time on this because I think it is misunderstood and misapplied by a fair number of people. So a key doctrine in the copyright law is the concept of fair use. Now, very simply, fair use is a defense once a copyright infringement claim has been asserted against you. Now, the fair use doctrine does allow for, in certain limited circumstances, the unlicensed use of copyrighted works. There are several types of uses which are permitted: criticism, commentary, news reporting, teaching, which is where people get tripped up, in my view, scholarship, and research. Now, those are all examples of types of activities that may qualify as fair use, but as you'll see, it's a little bit more murky than the way I just described it. Courts will look to 4 factors in determining whether the unlicensed use of a copyrighted work is indeed fair use. First, they'll look at the purpose and character, primarily whether such a use is of a commercial nature or is for nonprofit educational purposes. Now, we need to focus on that for a minute. When the use is of a commercial nature, I want you to think of the instance where any dollars or any value is being exchanged in connection with the performance. So in other words, we have, some of us host marching band competitions. We do take sponsorship dollars in from local businesses to help offset the cost of producing the show. We do charge ticket prices. People do pay money to come to a high school marching band contest or an indoor performance. That is commercial in nature. If there are, and I want you to think just very plainly of the idea that if there are any dollars flowing in any direction as a result of the performance, you are not in fair use territory. Now, if it's a high school end of year school concert where attendance to the event is free, there are no ticket prices, the parents and the community and the family can just walk right in and sit down and view the performance, that fits more into the nonprofit educational purpose if you are in a public school system. So that, for our purposes, that first bullet point is really, really very, very critical. And we should consider any competitive environment where there are tickets being sold to be essentially a commercial activity that takes us out of the fair use doctrine. Okay? And that, if there are any questions on that, I'm happy to field those. I know it's a little bit of a ambiguous topic. Now, while this is not specific to copyright law, I'm going to shrink this down a little bit. Whoops. Bear with me. Sorry, I hit the wrong button. Okay, here we are. Now, while this is not specifically related to copyright law per se or the Copyright Act, at the state level, there are likeness rights issues that we need to be careful of. And I know most of you cover this with your students in the forms of media, photo and media releases. But I did want to just hit this quickly also, that as we all know, you cannot use the likeness of another person for a commercially exploitative purpose without that person's consent. Typically, this happens when you use a group photo as of perhaps students or parent volunteers or something like that, and that photo appears in an ad for an upcoming contest that the school is a band contest. I mean, that the school may be sponsoring. So if you're going to use any photographs in your promotional materials, particularly if students are depicted in there and you can recognize who those students are, you certainly need to have on file a media release. It's a short document, 1 or 2 paragraphs. Does not need to be a book, but it does need to grant you the permission of that person to use their likeness. I have a form for that. If anyone is interested, please reach out after you view this, and we'll connect. So again, the steps that you can take to minimize the risk. You could develop content yourself, or use a stock photo service like Shutterstock, or Adobe Stock is also a good one. It's not that expensive. I think it's $40 a month, and it'll give you access to a massive library of still photography that you can download and use for this purpose. Whenever you've got third parties depicted in your content, if it's not faculty or instructional staff, you certainly want to secure a photo or video release. And I know some organizations do have, will have intranets or portals on the school website or on the ensemble's website. We want to be very careful to avoid a situation where third parties, mostly students, can upload their content to your site. So if you're going to run a Facebook page that is specific to an ensemble, you probably only want to let the administrator post content to that Facebook page. Likewise, even if it's a private intranet that the district runs, we want to be very careful about that topic. Now, in this presentation, I did have some trademark basics as well. I mean, I think it's important to know the difference between the two. copyrights and trademarks are two of the three categories of intellectual property, the third being patents, which is completely outside of what we want to talk about. Why this is important is that this happens with surprising frequency, where logos or branding of other organizations finds their way into your printed or web materials somehow. Happens all the time. We want to be very careful if anyone is providing you with a any branded content that you have their permission to use it. It can be as simple as an email, but again, logos, branding, we have to be very, very careful. If the ensemble has, and this is particularly the case where you may have an independent group that's not tied to a particular school district, you may want to consider registering a trademark to protect your logo, your branding. I mean, people work very hard and spend a lot of money to develop this stuff, so it would make sense. The cost of protecting your logo and your branding at the federal level, the cost of doing that is negligible relative to the downsides of not doing it. So if anyone wants to talk about that, certainly let me know after you view this. The penalties for trademark infringement are very similar to the Copyright Act. We won't go into too much detail here. And you can be assessed an amount equal to the defendant's profits, plus any damages sustained by the plaintiff, plus the costs of the litigation. So being on the losing end of a trademark infringement case can also be very, very, very damaging from a financial standpoint. So we just want to be very careful in our use of other people's logos or branding, and likewise, we want to protect our own logo and branding at the federal level. Now, part two of our copyright discussion is about licensing. So to review, the Copyright Act protects classifications of creative works, literary, dramatic, musical, choreography, etc. And the Copyright Act grants the exclusive right in 5 or 6 categories of activities, reserves those exclusive rights for the copyright holder. So you may be wondering, well, how do I get permission to legally use copyrighted work? Well, the answer is a licensing agreement. Quite simply, a licensing agreement is a written agreement which grants a third party the rights to use protected work. Okay, I've written the next great big hit song, and you want to use that song in your 2018 outdoor program. All you need to do is contact me or contact my agency, and we'll talk about that in a second, and ask to buy a license. And we'll be happy to license it to you, provided that we can agree on the price and we can agree on the duration of the license. Here are some key considerations. Now, this is written sort of from the standpoint of a creator. Okay, so we're on the different aspect of this. So let's just talk through all of these bullet points. Key considerations in licensing agreements. Number one, besides the price, and that goes without saying, but number one is the term. So we want to get rights from Katy Perry to to modify, to arrange and to perform an extract of her last record. Well, one of the key terms is going to be how long are we permitted to do that for? Is the license for a year? Is it for 5 years? Is it for 10 years? Typically in this context, your permission to use the work is going to be as narrow as the rights holders can get away with it. So in other words, you may get a license to use a marching band arrangement only for the season. And in other words, you get the license in August and the license expires on December 1st. You can only use it during the competitive season up through championships. And after that, the license expires. After the license expires, you do not have permission to publicly perform that work again. So you really want to think about, when you're having these licensing conversations with rights holders, you really want to think about what the material is, what the songs are, and how often you're going to do them. Are these songs that you're going to want to perform in May of next year, 6 months after the competitive season is over? If so, you have to make sure that the term of the licensing agreement is long enough to cover all of those performances. Evergreen provisions generally will not apply to what we are doing. What an evergreen provision is a provision that says when the first term of the licensing agreement expires, it automatically renews. That would require the licensee, the ensemble in this case, to be obligated to pay another licensing fee. I would say 99 times out of 100, you're going to have a definite term on your licensing agreement limited to 6 months or limited to 12 months, and that's it. The reason being that when your license expires, if you want to continue to perform that material legally, then you have to go back to the rights holder again and put yourself in the shoes of the rights holders. They view licensing as a possible stream of income, a stream of payments. So it benefits the rights holders to have as many payments as they can. Therefore, they would keep the terms of their licensing agreements as short as possible. Another thing to think about is territory. Generally, this is more of an issue in in popular music, or in theatrical companies too. This tends to be an issue where you may license a work in the northeast part of the United States to one group, and in the southwest part of the United States to another group. But there will be a geographical territory within which you can perform. So if this is material that you're going to take with you on a band trip to California, and we're a Pennsylvania ensemble, when you do your licensing agreement, take that into account. Basically, we would want rights throughout the United States, whenever possible. And a lot of times, marching band, organizations that license marching band content will try to constrain you into a very narrow geographical territory. Why is that? Simple. They can make more money by licensing it to multiple groups. So I'll license it to Group A in southeastern Pennsylvania. Out in the Pittsburgh area, I'm going to license the same material to Group B. And in the Harrisburg area, I'm going to license it to Group C. And now, as a rights holder, I have 3 licensing payments coming in instead of 1. So territory is actually a actually a term you really want to be careful with. Exclusivity, typically at the high school level, you will not generally see this, where the rights holder will agree to only allow your ensemble to perform the work for the reasons in the example, the Philly, Harrisburg, Pittsburgh example, for that exact reason. So professional rights organizations, the traditional ones are ASCAP, BMI, and CSAC. There are now popping up a couple of organizations that are specific to the marching space, and I'm sure you've dealt with them or have heard stories about them already in terms of perhaps over-enthusiastic policing. Now, this is one of the most important slides in the deck here. So generally, we've talked about licensing, but the question we have not asked yet is, we're getting a license, but what are we getting licensed to do? What are we allowed to do? Generally, there are 4 types of licenses. There are custom arrangement licenses, which is exactly what it sounds like. If you're creating a custom arrangement of a published copyrighted song, there is a license type for that you will need to obtain. A synchronization license, if you're using published copyrighted songs in conjunction with moving images. For example, you've publicly performed a song and you have had the performance license to do that, no problem. You now take the video content of that, however, and you are going to distribute that video content out on YouTube, out on the band's Facebook page, or you're going to create DVDs or digital downloads of video files and attempt to sell those. That is a different kind of activity than arranging or performing. What you would need in that instance is called a synchronization license. And this is exactly the reason when you are on Facebook and you see a video update from, pick anybody, it doesn't matter, but let's pick on Santa Clara Vanguard. So Vanguard uploads a video. Great, let's go click through and see what it is. What you hear is not the ensemble playing, but you hear a soundtrack overlay to the video that they've clearly purchased from there are commercial libraries that you can purchase music to use the soundtracks for. The reason being that if you wanted to broadcast video of a public performance, technically you do need a synchronization license to do that, or arguably that is a Copyright Act violation. So that's exactly the reason why you see that happen a lot in terms of the canned kind of soundtrack on top of video rather than the ensemble playing. The third type of license is a mechanical license. That is to say, if you are reproducing a published copyrighted song in an audio-only format, you would need a mechanical license to do that. And then finally, a master use license. This is the type of permission that you would need if you were using a specific recording in connection with your production. This pertains more to indoor guards than not, because they're performing along to recorded music more often than anyone else. But that's where we would go. That's what we would have to consider if we were incorporating specific recordings or samples of specific recordings in a production. And again, I should mention, I know we've been talking about the marching space, but for the jazz band directors, everything applies, and that's something I want to just stop everything for a minute and really emphasize this. The Copyright Act applies with equal force to everybody. So that's whether you are running a jazz band, an indoor percussion ensemble in the concert sense, whether you are in a indoor guard or indoor drumline scenario, or whether you're in an outdoor marching band format. Any type of public performance, regardless of the format, has to consider all of these issues. So that's something I want you to really hang on to conceptually. Now, there was an issue a while back where a performing rights organization started throwing this theory around in multiple parts of the country, that performing ensembles needed to obtain what are called grand performing rights. Now, this is different than what we just talked about in the prior slide. Grand performing rights are attached to what are known in the copyright law world as dramatico musical works. Think of Broadway musical productions, or of ballets, or of operas. So, for instance, let's say we wanted to perform Bizet's Carmen in our outdoor program. Carmen is an opera. I mean, yes, there is a very popular musical score that people know that is attached to the opera, but Carmen is an opera really at its roots, not necessarily just a symphonic piece or the overture or a medley of themes. The reason why this is important for us is that grand performing rights are not monitored or administered by any master organization like ASCAP or BMI. If you had to obtain grand performing rights from a composer, you would have to go to that composer's estate or their representatives peer-to-peer. You're not going through a rights organization. The price for obtaining grand performing rights as a result, and this is just basic economics, are always much higher than if you were just contacting ASCAP and getting a license to arrange a particular song. I should say this theory has been unproven. I have not seen any developments yet where an ensemble actually did have to go through this particular hoop in order to legally perform their works. I think if you generally stick with the 4 types of licenses that we talked about, you are covered 99% of the time, provided that you pay all the licensing fees and get the right kind of coverage. But you should be aware of what grand performing rights are, because if you ever are contacted by a rights organization using these 3 words, you should contact your legal counsel right away, because this is of all the things we've discussed, this is one of the newest and least certain environments that you could be in. So hopefully none of us ever have to step in that, but if you do, again, contact your counsel or your school solicitor right away. Okay, and we did talk about that, and again, the grand performing rights have to be obtained directly from the rights holders. There is no, there is no master licensing regime for this yet, and there may be. There was a litigation matter in federal court in California that I've been monitoring because it has a lot of relevancy to what we're talking about. Trisona Multimedia LLC is a copyright servicer. They're based in the Southwest. I know a lot of you have heard of them or have interacted with them. They brought a suit. They brought a lawsuit, a copyright infringement lawsuit in federal court in the Central District of California in 2016 versus the Burbank High School Music Association, along with a handful of other defendants. This case was a lightning rod for a lot of reasons. Number one, the copyright servicer not only sued the in the list of defendants, the Booster Association was named as a defendant. So this was the first time this has ever happened, where put yourself in the standpoint of your band booster association being involved in a copyright infringement suit for something that the school, that the band director decided to do, or the creative team and on the marching band staff decided to do. We all have very good relationships with our booster associations, obviously because of funding scarcity through the typical budget process. We certainly need healthy booster associations to raise money for our programs, and we always want to protect those people. In addition, the director of the association was sued as a defendant, and all the individual board members under a copyright infringement claim. There were very serious implications, possible individual educator liability versus the qualified immunity that most school teachers typically have in Pennsylvania, for sure, for certain, for most activities. The directors and officers insurance coverage for the association board likely does not cover copyright infringement, which exposes all of the band booster directors to liability. Now, since this case broke, there has been some sanity in this federal court, which the developments were that on summary judgment, Brett Carroll, who was the choral director, was entitled to qualified immunity from suit, and he was dismissed. In addition, I'm just going to move this over here. In addition, the other update is that in May, the high school choir boosters were excused from the lawsuit as well. Now, just because the choir director and the booster organization directors were excused from this particular suit, that does not mean this won't happen again. I will bet you, I'll bet you anything, we are going to see this lawsuit again in a different district, in a different federal district, and I'm going to, I'll monitor those and update the group as I see new relevant litigation on this. So in summary, and again, I want to thank you for your time and your energy. I just want to hit 4 points, 4 takeaways. Or actually 3 takeaways because we're not in WGI. So let's ignore that first bullet point. We certainly want to make sure that we're licensing with the performing rights organizations. We definitely want to obtain licensing for our ensembles, regardless of any kind of master agreement you may believe that you may be a part of. The grand performing rights issue, that when in doubt, assume that you need them and then contact your counsel to figure out how we can justify the fact that you don't. Again, I think that the grand performing rights is a landmine, and eventually the rights organizations are going to figure out a way. Well, I'm having some technical difficulties here. The performing rights organizations are going to figure out a way to start asserting that grand performing rights theory. The bottom two are among the most important takeaways. Number one, plan early. So start your show music selection earlier than you typically do to allow plenty of time to deal with the licensing issues. The more time you allow yourself, the easier time you're going to have. What you don't want to have happen is that the show music has been taught, the drill's been written and taught, the marching band's ready to go with its competitive season, and you're still chasing licensing issues. Not a good spot to be in. And finally, you document everything. So when you are in your licensing negotiations, make sure that you keep your emails, keep all of your correspondence with the rights organizations. Make sure you keep copies of the licenses handy. I think it's a very good idea to have a binder that in the case of marching bands especially, it's a good idea to keep physical copies of the licensing documents handy. It seems unbelievable to me that a rights organization would send representatives to public performances to verify licensing, but I personally have had two people tell me in unrelated incidents that they were involved in that exact situation. So when you get your licenses, print them out, put them in a 3-ring binder, and keep them with the director or with the associate director, or have someone in charge of that binder so that you have those on site. Again, thank you very much for your time. I really enjoy this area of law, and I want to help everybody succeed as best I can. And thanks again. And if anyone has any questions, please feel free to email me or contact me through Facebook or Twitter or Instagram. The law firm's on all three. So thanks again. Best of luck in your future productions, and I hope to see you soon. Take care.